Mr. Chairman, we are live.
Okay, thank you. Meeting will come to order. Diana, will you take roll, please?
Okay, Representative Andrew,
Here.
Representative Brown,
Here.
Representative Connolly.
Excused.
I think she's going to be on Zoom.
The text message I got said that she needed to be excused.
Okay, thank you. Representative Harshman. He's excused. Representative Nyman.
Here.
Representative Newsom.
Here.
Representative Obermuller.
Here.
Representative Summers.
Here.
Chairman Paxton.
Here. Okay, we're going to continue from where we left off on Senate File 68. So Senator Ellis, if you would come forward. No,
Because he's here.
we were taking testimony, as I remember. Do you want to?
Thank you, Mr. Chairman. I was finished with my remarks, but if you wanted to open it to public comment, I would just ask that before you close public comment entirely, if I could circle back and just offer a few remarks at the closing. Thank you, Mr.
Okay.
Chairman.
All right, so public comment still open on Senate File 68. Anyone in the audience that would like to comment on 68? Yes, come forward, please. Identify yourself. Tell us who you represent.
Superintendent Abrams from Laramie County School District number 2. As I review Senate File 68, I see just one difference, and that is a sentence that talks about parents being able to excuse the absences. And I certainly would say, particularly as we're dealing with the absences, there is no more important relationship than the relationship between the school and the parent. And I'll be the first to admit that we don't always get it right. Sometimes letters go out from our district that probably shouldn't have went out. And so we get it all worked out. But I want to talk to you about my concerns with the bill and to share 3 brief examples of how this bill could potentially impact. The first is a student this year who in the first semester missed 32 of 89 days. In the third quarter, he's missed 20 of 46 days. This is a 7th grader who has anxiety about COVID. He's anxious about a lot of things, and we're more than happy to provide him a virtual opportunity, but his parents don't want to do that. This bill, as it is written now, allows that parent to write an excuse for those 52 days for this year. And really, as it's written, if they write the excuse, we're obliged to accept it. It doesn't give us any way to really do much about that. Now, this parent would tell you that they would rather their son is in school, but it's just not worth the fight in the morning. And so they write an excuse, and they have a doctor that's happy to support that. The next one is a student, and this happened 2 years ago. He's on an IEP, refused to come. His father tried to get him up. His father is a single father, did his best, but could not get the young man to come to school. So the IEP team met, and they felt like a residential placement was in order. And so he went to Jackson, where he went for an entire year at a cost to the district of $80,000. He did phenomenal. He excelled. He came home, and for 3 months, it was like a different student. And then his father and him got into the same unhealthy routines, and he dropped out despite our best efforts. And this was done with the father excusing the absences. The last one happened just last year. We had a student who was tragically killed in a car accident. The sibling was devastated. Once again, it was a single parent. This young man attends about 50% of the time and gets any counseling and support that he's going to get, he gets at school. This policy or this bill as it is currently written would allow that parent to just write an excuse. And we really don't have much help. We've involved DFS, and DFS says we've got bigger fish to fry. We're dealing with neglect, we're dealing with abuse. It doesn't, just not showing up at school is not, when they triage their cases, attendance isn't there. Just today, I got off the phone with the district attorney who deals with these types of cases. He said in light of the 10% budget cuts, that his staff has been cut in half. He says, I don't have the time or the ability to deal with these cases. He says, it's not that I don't want to, it's that I just have bigger fish to fry. I don't want to say fish to fry, but they're just overwhelmed. I don't think that we shouldn't have a bill that deals with attendance. And in fact, we currently do. In fact, all districts do. They're required to by statute. And I don't think that allowing students to be gone for appropriate reasons, funerals, all those things, for whatever that case may be, I don't have a problem with that. In fact, I pulled my own daughter and took her for 2 weeks. What I have a problem with is the way this bill is written that would allow students to just be gone for an unnumbered number of days and the parent being able to excuse it. And I just don't think that's where we want to be. I do think that there's work to do. I do think there are things that you perhaps could do with this bill that would help, but the one sentence that is in there now that changes it, I don't believe it serves the purpose that we want to serve. And I stand for questions.
Okay, questions from the committee? Okay,
Thank you.
anyone else like to testify?
I think you've got Kevin Mitchell.
Yeah. Looks like we have Mr. Mitchell on virtually. If you're ready to go, we'll take you next.
Chairman Paxton, members of the committee, my name is Kevin Mitchell. I'm the Executive Director of the Wyoming Association of School Administrators, and I'd like to share some comments on this bill as well. In the interim in 2019, we worked with the sponsor on a previous bill dealing with absenteeism that didn't make it through last year. And we were not involved in this particular piece this year. However, my concerns are still the same. The language in current law, the definitions are quite confusing. And my recommendation would be that we stick with redefining truancy in particular in state statute. In school systems, truancy is when a student comes to school and then leaves school property without permission. That gets confused here when the definition of a habitual truant is 5 unexcused absences. They're 2 entirely different things. An absence is a student doesn't attend school at all or part day and then is excused, but has permission to leave. In our terminology, truant is when a student has permission and leaves once they've been on school campus. So that's some of the issues that I have. And I agree with the sponsor of the bill. We need to clean up some work in absenteeism, but I think we should start with the definitions that are already in state statute. So that would be my recommendation, that we look at cleaning up the language before we add anything to existing statute. And I'd like to add, in my experience as a superintendent and as a principal, this is a very difficult issue, but it doesn't have to be. If there are good policies, good definitions in place, it actually is an opportunity, I think, as the previous speaker said, a way to open positive communications between a school and families. You know, I got the letter myself after 5 absences as the superintendent, and the school knew where my son was. He was in the hospital, and I was staying in the room with him while he was in the hospital. But it didn't offend me when I got the letter. I just went to the school, and they remembered that I had previously pre-approved his absence because of his personal illness. So the letters do sometimes come automatically out of an automated system, and that may be unfortunate, but it doesn't have to be a negative thing. It can actually be a positive thing that the communication lines are open. And then secondly, And lastly, if you have a very creative policy, this actually does turn into a positive with families, because after that 5 absent letter comes out, the school then offers assistance to the family to reduce absenteeism. I remember one of my instances where I couldn't get some children to school, but the grandmother agreed to get them to school because the mother wouldn't. So these are opportunities to create positive relationships. So, Mr. Chairman, thank you for my time to speak, and I stand for any questions.
Okay, Representative Brown.
Thank you, Mr. Chairman. Mr. Mitchell, just curious, you said that there's some confusion in unexcused absence in our statute. And as I went up and I pulled up unexcused absence, it says unexcused absence means the absence is defined in the policies of the local school board of trustees of any child required by this article to attend school when such absence is not excused to the satisfaction of the board of trustees by the parent, guardian, or other person having control of such child. I guess I'm a little confused as to the confusion behind that. It seems to me that that's pretty straightforward, that as long as you have a definition in the local school boards, that it seems pretty straightforward. Can you elaborate a little bit more as to what definitions you need cleaned up or think that we need to clean up inside a statute before we go through with this bill?
Mr. Chairman,
Sure. Go ahead.
Representative Brown, if I said that, I misspoke. I meant the definition of a habitual truant is confusing because it turns unexcused absences into truancy. And truancy is not an absence. It's when a student leaves property without permission. That's what the definition that I believe needs work.
Okay, other questions from the committee? All right, thank you, Mr. Mitchell.
Thank you.
Anyone else like to testify? Clarissa, do we have anyone else virtually that have their hand up?
Mr. Chairman, I don't see anyone with their hand up at this moment.
Okay, anyone else in the room like to testify? All right, before we close public testimony, yes, bring her the bill, come forward, please.
Thank you, Mr. Chairman and committee members. I want to just respond to a few things. But first, I just want to kind of clarify. I know that your committee received an email from the School Boards Association last night, and I just wanted to share some thoughts and some concerns I have as just kind of a legislator who's concerned about process. You know, I don't think it's any surprise to many of you that years ago I used to lobby. And so I've sat through every committee under the sun. I've watched a variety of chairmans run really great meetings, not so great meetings. And there was one legislator in particular who used to chair your House Minerals Committee, and he was a gentleman, but he was tough. And I remember when, you know, someone would bring an amendment, a proposed amendment to him, he would ask if it was a Senate file, did you run this? Did you work this in the Senate? And have you visited with the sponsor? And you would watch people at this dais squirm if they had to say no. And I always respected that. And it really left an impression on me of the need to work the process from start to finish and to reach out to sponsors of the bill. So when I saw the email last night, I was just really disappointed because when we had this bill in the Senate, we heard it in committee, and the School Boards Association said, you know, we have concerns. What about our ability to verify? And I said, you know, I wish you would have called me yesterday or the day before. We could work on language, something I love to do. And so I begged, please, let's work on some language. So immediately got off the Zoom, got on the phone and said, what language do you want? And so you'll see the addition of language in this bill that adds the sentence about verification. And that was it. I brought it forth in good faith. I didn't think it was necessary, but in good faith, I brought it to the Senate. I urged my colleagues to adopt it, and they did. And so when I saw the email last night saying they want that sentence stricken, I thought it was confusing. And then the additional changes, I just don't know why they weren't asked ahead of time on the eve before hearing, and why they weren't asked in committee when we had the conversation. And so I just want to throw that out, Mr. Chairman. You know, I don't have it all figured out. I just recently got a gavel myself. I know I've got a lot to learn in that role, but that's something that I'm going to try and do. And I did it already as respect for your House members when they came over and people were asking for amendments in House files. I asked that very question. Have you visited with the sponsor and did you work this amendment on the House? I think those are fair questions. So I wanted to offer that and then just really clear up some clarification about the content of what this bill is trying to achieve. As I mentioned, last year we had a big bill and I was told it was too big, too confusing, needed more work. And so if you look at Senate File 15 from last year, this discussion of what habitual truancy is very confusing. I don't disagree with that. But to say that we need to address this in this bill this year, I again was trying to take it in manageable pieces. If you look at our statutes of unexcused, what's unexcused, there's a difference between what we would consider a habitual truant and someone who is willfully absent. So in Senate File 15, if we wanted to go back and study that bill from last year, we actually created some really clear definitions. Habitual truant was someone who disobeys the lawful demands of the parents or the child's parent, guardian, or custodian or other proper authority to attend school. Those are the instances where you drop your kid off and they cut class. We also created a new definition of willful absenteeism. This one placed it more on the parents being at fault for the kid's absence. And so we had these new definitions, and combined and collectively, those would be unexcused. Okay, so two different concepts of why a kid's gone. But when we start tinkering with those definitions, then we have to go back and do all the conforming amendments in your child protection statutes, your habitual truancy statutes, and that's where it starts getting really big and really confusing. So again, as a preview of where I think this committee needs to have the discussion in this interim, yes, let's draw a clear line between what's a habitual truant, who's willfully absent, and those two combined are your unexcused absences, okay? So I don't disagree, but I would just ask, you know, I've heard, I just had a conversation with Representative Summers yesterday about also the request to take out the recognition that people miss school for grievances. And as I thought about it, I'm going to try not to get emotional, but it's really important in this bill to recognize that parents and students have some rights. When I get this letter, I appreciate that some people throw them away and think they're a joke. I take them seriously because when I read this, if my daughter misses too much school, she could be placed on academic probation. That's a big deal for a kid. And so when we don't recognize, I think, really minimal standards of what's appropriate for missing school, I think we've just lost our way. I think most people, at least in your employment world, they recognize bereavement. And I think there's a workable solution for districts to grapple with. I appreciate a willingness to look at what's unexcused. And I want to be clear, this does not allow a parent to excuse their children. That's not accurate at all. This bill is about having parents work with the school district for a pre-approved absence. That's not giving any authority to a parent to merely write off missed school days. This bill purposefully allows districts to write the policies they want. It's not prescriptive. And so as I've read this, I just keep thinking, what is the problem? What are the concerns? A kid is sick. They have parents and loved ones who are dying, and we're not going to recognize that they can be gone from school. We can't figure out a policy to make that work. I'm sorry, we need to do better. This isn't just about parents, this is about kids. And I'll go back to the example again, and this is where I get a little choked up. When my mom was dying, we knew her end of life was near. She had Alzheimer's. She was 67 pounds when she died. I wanted to spend time with her, and I wanted to pull my kids out of school. She lives 500 miles away. And the thought that came to my mind was, can't do it. Kids can't miss school. Can't take them out. Kids can't miss school. So we kept them in school, and she died. I don't want parents to have to go through that. And I think this last year in COVID, we have learned some really valuable lessons that we can make it work with our districts. In that instance, wouldn't it have been great if I took my kids out for at least a week, but made arrangements with their school for them to Zoom in and still participate, but get to spend breakfast and lunch and dinner with their grandmother? I feel strongly about the language, and I feel strongly about this bill. And the boogeymen that are out there misinterpreting what the language says, please read it carefully. I would urge your strong passage of this bill.
Representative Brown.
Mr. Chairman, Senator Ellis, I like this bill. I'm a co-sponsor on this bill. And as I look back at this, I see that we're going to tell that the school boards shall define habitual truancy, but then we have our own definition of habitual truancy. How do we fix? I know you brought a bill, and trust me, I was a big fan of that bill last year as well. How do we fix that we conflate the two. You have statute and then you have their rule. Is it, maybe you can just guide me in the direction is that they can be more stringent than, but it's kind of like our federal rules. We can have, our standards must be as at least as stringent as, but no lenient, more lenient, but we can have more stringent standards at the rule level. Is that right?
I think that's a fair assessment, Mr. Chairman, Representative Brown. This language that I said, where we were trying to create a clear delineation, we didn't go anywhere with that. That's still out there. So when we looked at the definition of habitual truancy last year, right now it's defined as any child with 5 or more unexcused absences. So I think we took out the 5, again, recognizing that there might be school days that have 4 school day weeks. So 5 maybe isn't the right number, but we want districts to maybe prescribe that by rule. All I can tell you is, you know, that one of the prior presenters talked about meetings and we're trying to work out solutions. A lot of work has been done, a lot of work. Of all the bills I've worked on in the legislature, I can tell you this one I've spent hours and hours on. More work to do, but I think there's a solution. It's not there today in this bill, but it was because of last year. And what I was told was the bill was too big, too complicated, take it in smaller chunks.
Okay, further questions? Yes, Representative Harsh.
Yeah, thank you. And, you know, and I appreciate your, you know, all this is about people, Senator Ellis, and I appreciate your, but I think, and, you know, and I support the bill, but I think too, I want to kind of back up a minute and raised 4 of my own kids, taking them to funerals, taught 35 years. I've never had a school board member or a principal or a teacher not express their condolence for these heartbreaking, that happen all the time because schools are in the people business. And so I just want to say, I mean, I don't think there's any school in Wyoming that would say, hey, you can't take your kid out, go see somebody in your family who's, I mean, bereavement comes across mine all the time as excused absences. And so I just want to, if people out there listening to Zoom, like our schools are sometimes saying, oh, you can't go to your grandmother's funeral. I just don't think that's happening. I just don't believe it's happening. I've never seen it happen. And so I think schools have treated people with a lot of compassion, and so I just want to kind of, let's pull us all back. If we got to clean up some language, make it better, let's do that. But I think the reality is there might be some inconsistencies in the statute, we'll work on it. But I think the consistency of the hearts of Wyoming people, I don't question that. I think they're all in the right spot. And so I just think let's bring us all back to a little bit of all of our own experience in the real world on this deal. I don't think anybody's going to get thrown out of school for those kind of situations. Everybody's got a big tender heart on those. And it's just, and so I appreciate your work on this. This bill is going to be fine, I think. And I think we'll just keep working it better. Now, and I will say this, and this is my 19th year, and I think people sometimes say, you know, I mean, it's a process to work through both bodies. And, you know, I think of the Hathaway Scholarship happened on the final day in the second house. And so you just keep making it better and better and better. And so I don't think there's any, as you learn more and you keep moving forward. So I think that's what our job is, this committee, to kind of, this group genius, right? No bill, very few bills go through the thing unamended. And that's what we're supposed to do. So I think, you know, I think our good chairman, everybody's going to follow the proper protocol. If it gets amended a little bit, hopefully we make it better and we'll keep working on it. And it's never ending, you know, it's a never ending process. So appreciate your work and your presentation, Bill. It's been really good, really has. But I just want to bring us back to really what's happening on the ground. When a kid misses school, any period, their parents' phone buzzes. They know it instantly. It's not the old days where you're filling in a little bubble on a Scantron. I marked kid absent my classes, parents, boom, no instantly. And so I just think we'll keep working this, but I just want us to all kind of know what's going on the ground out there. So thank you, Mr. Chairman.
Hey, other questions, comments from the committee?
Mr. Chairman, may I respond to that?
Yes, you may respond
Thank you, Mr. Chairman.
briefly.
I want to be clear. When I spoke to the attendance officer, because I was really upset getting the letter after calling every morning, explaining our circumstance, really nice lady I spoke to. She was sympathetic. That doesn't excuse the fact that I got a letter saying that my daughter is on a path toward being placed on academic probation. We live in a legal world. These are legal processes. We need to afford families and students some protections and base minimums of what's excused and what's not. So I want to be clear. I agree with you. Wyoming people are great. We need our statutes to probably catch up to where our heart is.
Yeah.
Okay, let's close public comment. Committee, what's your pleasure?
Move the bill.
Moved by Brown, seconded by by Nyman down at the other end. Okay. Folks,
Mr. Chairman, I have an amendment.
okay, go ahead.
Thank you, Mr. Chairman. I would like to amend the state fair back into the absences. I'm going to kind of disagree with the bringer of the bill that state fair is a special circumstance and that some students that are in FFA would be excused while others that participate in 4-H would not be excused for exactly the same event. So what I'd like to do on page 2, I don't know whether you do this at the end of line 10 or the beginning of line 11, but insert after the period on line 10, insert a new sentence that says, students participating in the annual state fair held under WS 11-10-101 as an exhibitor shall be considered as participating in a district co-curricular activity program and shall be defined by the board as an excused absence and a period.
Second.
Okay, seconded by Summers. Discussion on the amendment. Sensing you're ready to vote,
Question.
all in favor signify by saying aye.
Aye.
Aye. All opposed, nay.
No.
The amendment is carried. Okay, further amendments? Further comments?
Mr. Chairman, I think it's been clearly stated. I think we've got a lot of work to do, and I would hope that this committee, as we look forward to this, I think you saw some passion here from both sides. I think we've got a lot of work to do, and I completely understand where the good bringer of this bill is coming from. Last year, she brought a bill to fix literally all of this and was told that it's just too much. Come back with a smaller piece. So she's come back with a smaller piece, and we're saying, well, you should probably fix it all at the same time. This piecemealing isn't going to work. The infinite wisdom of legislating. So I would hope that this committee would consider looking at this deeper and diving into this entire process deeper as we go into the interim. Thank you, Mr. Chairman.
Representative Summers.
Mr. Chairman, thank you. And I guess I'm not really sure what the good representative was talking about because I haven't heard us in this committee, as we've discussed this bill, say that we need to bring it in, everything in at a time. So I don't know where that's coming from. So maybe it's because I don't reread my emails. But anyway, I do have concerns, and I've talked to the sponsor about this, about I don't mind the first sentence, but I get kind of wrapped up in the rest of it when I get to thinking on it. And so I may or may not bring something on the floor to try to fix this, but I'm going to support it for now, but I think there's some issues here still.
Okay, other Representative Overmiller.
Yeah, thank you, Mr. Chairman. I'm not going to support it for now. I think the basic premise of this little piece that was pulled out was personal offense to the letter that was generated by the computer. I don't understand that level of offense to that, so I'll be a no vote.
Representative Brown.
Thank you, Mr. Chairman. So I do think, Representative Overmuller, I think there's a portion of that. I certainly think that there's a little bit of an ability when we're sitting behind this dais and making these rules that we have that intention and the inclination to fix that. The one thing that I will say is the difference of what this bill is actually doing, in my opinion, is the may versus shall. And as my notes clearly state here, the first lines that were coming out of this is currently in state law, we have this as an opportunity for the school district to define these. And whether they do or not, if you do not follow the rules, you can be charged with a crime as a parent. And the kid technically could be charged as a truant. And so what we're doing here, above all else, if we work on the language below this, if you look at line 2, that word shall is just dictating to the school boards that they need to have a policy in place. I'm frankly shocked that we don't have that. And I think what we define underneath that is our responsibility. But the fact that this was a permissive statute and that you could be charged underneath the permissive statute is really where the nexus of this became an issue.
Okay, yes, follow up.
Thank you, Mr. Chairman. I appreciate those comments. On the other hand, we didn't hear any testimony other than offense to receiving this note. We heard no testimony that there's any actual abuse by any school in this area about not recognizing legitimate absences. So it just seems to me like the reasons just weren't presented why we should go this way. Thank you.
Well, it's been my experience, there are some things that can't be legislated. And we may be in that area right now. So further discussion on the bill as amended. Question has been called. Roll call, please.
Representative Andrew,
Aye.
Representative Brown, Representative Connolly, Representative Harshman, Representative Nyman, Representative Newsom, Representative Obermuller, Representative Summers, Chairman Paxton.
Aye.
8 ayes, 1 no, and
Okay,
1
bill
excuse.
passes.
Oops, so it'd be 7
Next bill
ayes.
for our consideration is Senate File 130. Senator Driscoll, come forward, please. You have the floor.
Chairman Paxton, esteemed members of the committee, thank you for the opportunity to present. I would point out in my over 10 years in the legislature, this is the first time I've ever got a bill to House Education, and I'm proud to be here with you. So thank you. I hope you treat me well. This charter school bill, I think I visited with all of you some about it. This is, as you all know, Wyoming has charter schools already. We've got at least 5 right now in operation out there. And this is a extension of those charter school laws that were on the books that extends charter schools into a little bit different areas. The way they are now, if a district doesn't want a charter school, there isn't one. There isn't a way to get one there. And they offer choice. The first thing that I'm going to bring out for everybody, and I think I've talked to all of you about, this is not a bill to save money. It's not going to, I don't think it costs any more particularly, but it's not going to save money. That's the first place everybody jumps for trying to save money, and it's not. It's to provide choice in education and to provide some alternatives. And I think it is really an important bill going forward as we look at school funding, because these smaller schools, which I come from one of them, and Representative Nyman lives in the same district. Our school's gone from about 120 kids when I was in high school down to, I believe, around 40 now. And as these cuts go on, it's going to get more and more difficult to keep these schools in business. Charter schools, hopefully within the district, provide an opportunity for our local school board to kind of provide an alternative type of education and still maintain a hometown school. And I think that's critical importance. As far as taking over districts, I think we've seen in the areas that have charter schools, i.e. down here, they don't catch fire and they're not putting schools out of business. They're giving parents a choice of a different place to send kids, sometimes a different type of education. And I think that's important. It's hard to educate kids now. I'm looking at some educators here. You folks all know how hard it is to get kids to be interested and want to go to school. This provides some of them, and the example I use my own area because I live there. This is somewhat about me. Is our kids tend to be rural kids that work at sawmills and work on ranches, and they're a good part of them aren't college bound. And that's true for a lot of our district. And this would give us a chance to actually get some of those kids where they can further their education, still get a solid education, but have one that they feel like makes a difference in their lives going forward. So with that, I'll kind of walk through the bill, and I'm going to do it pretty fast. We don't have a lot of time. I think you folks understand it. So we just delve into it. And really the base difference of this is if a district decides that they don't want a charter school, and they've got a petition, a fully filled out petition that's done, and those parts are in this bill that says what you have to do. If the district does not do it, then they go to a higher authority, which in this case is the SLIB board. And as I understand it, we're going to proceed amendment probably, but I'm going to do it with the SLIB board for now, but we're talking that higher authority, whatever it is. They present that fully done application. Local board presents their side of it. The charter school presents theirs, and the higher authority decides if they're going to grant a charter school. They look at facilities that the schools have in the area that might be able to fit. Charter school has to pay a lease to it. But the district can be compelled if they've got either underused schools or schools that are on a surplus list, they may be compelled to allow those to be used by a charter school. That's in the bill. So it really allows an outside authority. If the district forms it themselves, they get 100% of the ADM, just the way we do now. That's all there. That's what's in the ones that are here. Should they go to that higher authority, this bill makes it where they get 85%. And we really tried to make it where it was sweetened up so that they did work with the local district, because the number one choice would be to work with the local school board and the local district. That's my belief all the way across. But if you've got a board that just is anti-charter school, this gives a local community an option to get into that. So as we go through it, we go to page 1, and then what we've been talking about is authorizers. And we go through, and page 1, page 2 basically talks about the authorizers, and 3 is just the titles that it goes into. Pretty simple the way it goes. Bottom of page 3, duties of board of trustees, and then talks about what schools do. On to page 4, talks about the facilities and how they're going to take care of them if they do it, how they do it. Talks, and this is existing, a big part of it. Drop down to line 16, and we strike pursuant to a contract and add on line 17 within the boundaries. So a charter school is not going to be a countywide entity. It lays within your school district boundary. For example, down here, we've got Laramie 1 and Laramie 2. If you're going to form a district, you're going to decide which one of them that a charter school wanted to go to. They petition the board. And if it comes up, it lays within that district. That's the overseeing board on it. We go on 3, we're just existing language onto page 5, come across onto page 6. And this is the opportunity part of it. And we just go into it and we strike the word "the" on page 4 and get rid of the district structure on line 4 and add districts in. It's mainly just conforming. Middle of the page, line 10, new charter school. This is existing language. And then we add "or charter school." And then we strike a piece that's in there that was fits for what's there now, and have inserted new language on line 15 that talks about it being a public school operating under the terms of a charter contract between the Charter Schools Board and its authorizer. That contract's all important. We get into that later on. You're going to hear different things as they don't have to follow the rules that a normal school does. And that's absolutely true. But the devil's in the details in that contract, because when they sit down to do it, be it with either the authorizer, whoever it may be, or the local school board, that's where their rules come. They've got to follow all the normal testing procedures. They're going to follow all that. They're going to follow the federal. But in the case of these smaller schools, it may allow some flexibility in teachers that can teach multiple subjects with having it and different things. And that's why I grew up, folks. My librarian in my school taught physics, chemistry, math, English occasionally. I believe he had a degree for maybe chemistry, but he taught all of that in advanced maths. I think we can still do that with charter schools. We've done it before, and those kids get good educations. I certainly didn't hurt when I went to the university as far as what I had from him. So bottom page 6, we go into the authorizer, and the authorizer is either a school district board or it's a SLIB board as it stands in the bill. I went to the SLIB board. I'm going to explain, and like I say, it may amend out. We visited with the superintendent, and we talked about how to go about it. we felt like the best independent entity was the SLIB board. These guys make hard decisions and they're good. They follow through. You put that on the state superintendent and it potentially creates friction between a local school board and our state superintendent. I'm going to look you in the eye and tell you, I don't want to have our superintendent crosswise with the school board over a charter school. We're here to educate kids and do it the right way without causing more friction in the system. So go on to page 7, talks about the charter. Charter contract means charter executed between it and the authorizer. On to line 5, the application is the application that's done, and that's gone into here. And that application has a standard part of it, and then it has a part where it's written in where they put in the exceptions and what they have to have. That may mean professional teaching standards board. It may mean different things, and that's what they negotiate through. On to line 9, Department of Education, line 12 on page 7, education service provider. And this just definition means a for-profit or nonprofit education management organization, charter management, or any other partner any charter school contracts with for educational program. That'll get in a little later of why that's there. Existing language, bottom of page 7. We get to the top of page 8. And once again, we strike out the district thing because of the authorizers. Go down to line 4 and 5, head through that. And once again, no charter school shall enter into a contract with an independent management company. And we inserted or education service provider without prior written consent of and we struck out the district and it goes to authorizer. And this is the clause that keeps you having the for-profits in there. The guys are making the deal. It's if they're gonna do anything different off a normal deal, it's gonna have to be authorized by it. Middle of page 8, charter school requirements authority, get down to line 16, and we added some more language to it. And the language is to any student in grades kindergarten through 12. Makes it clear that the charter school is not a preschool and it's not after graduation school. It just covers K-12. Same as deal. Line 19, we've got a strike. And it says, if a charter school is granted by a school district, charter school shall be a public school within the school district that grants charter. And then we added the new language that's if they don't. Charter is granted by the State Loan Investment Board. Charter school shall be an independent school within the district where the charter school is located. Charter school should be accountable, and we struck the district board to the authorizer. And so what it really says, if the local board doesn't go along with it, there's going to be another school board formed, and they'll operate side by side within the district. They'll operate the charter school. Local district will keep doing K through 12 the way they have been. Existing language down to the middle of the page. We get down to line 15 on page 9. We added some more language. Charter school specializing at-risk or special education students may give preference enrollment to those students. Charter schools sponsored jointly or separately by the Eastern Shoshone or Northern Arapaho Indian tribes may give preference to a tribe or to a student who is a member of the eligible for membership of the tribes.
We could
Tribes
just stop
teamed
you
up.
for a second. We have a question right here, I think.
Yes, sir.
Mr. Vice President, or Mr. Majority Floor Leader, sorry. Question for you back on page 8 and 9, where you're talking about I'm believing this is kind of a carrot and stick approach to the school districts to approve that. Is that right? That you're trying to get like, hey, we're hoping that the school districts will work with these charter schools and approve. And if they don't, and it goes up, you guys are going to have to operate and you're not going to have any jurisdiction over this charter school that's operating within the bounds. Is that kind of what you're doing with that?
Chairman
Go ahead,
Paxton,
Senator.
Representative Brown, that's absolute what we're doing. You'll find later on in the bill, they get 100% funding, they get all the control if they work together. If they don't, they lose control, and the charter school loses as well because they only get 85% of the ADM. It's actually a savings, but they don't get fully funded. If they choose not, we're trying to make both sides have big incentives to get together, because my intent is not to create division within our districts. It's to get the best education with choice we can get. Thank you. So we go back to it, strike out, we get down to the bottom of page 9, and we went through the Native American, the tribes. They came to us and asked for that. The special education, we may end up with a charter school that's purely special education. That's why that is put there because it may be a better place. We all know what special ed costs, and if somebody can get creative, it may be a different one. The other part that we go into it, and I can tell you, it's not written specifically, but it's in there. These charter schools may not discriminate on churches, sex, special ed. They have to do the exact same rules that we do in K through 12, and they randomly, if they have more applications and they do it, they randomly select the students. They don't get to sort through and pick out ones that score higher, et cetera. So on to page 10. We do just a couple little deals to put the authorizer in and clean it up. Line 7 on page 10, charter schools organized by a school district may include school board members or school district employees in the governing board. That is different in our schools. We don't let our schools have employees on the board. Charter schools, we felt like very often you may want a teacher or someone on the board to help do it. They're a little bit of a specialized school, so that's a change. Middle of the page, we go back into the authorizer language a few times, and same at the bottom. And then we strike at the bottom of page 10 for the person enhancing the terms of any lease.
Hold on just a second. We have a question.
Chairman Paxton, thank you.
Mr. Chairman, thank you. And welcome, Majority Floor Leader. My question is back on that notion, and in my amendment, I don't mess with that section. But it really creates a conflict if you have somebody that's on a board that then is hired to do a job by the board. And you know that you never see that anywhere. So kind of tell me your reasoning behind that.
Go ahead.
Chairman Paxton, Representative Summers, the thoughts on it were these generally, and maybe they'll get bigger, and I'm happy to strike it out, but real often these charter schools are tiny little things, and it's hard to get really good qualified people that care about the school. And it does create a little bit of a conflict, possibly. But where we live at, and I go back to Representative Nyman, we almost have it, even though it's not legal in Wyoming, because our county's small enough. We've got spouses and members of the school board that got family that works in the school. So we're used to it where I live at, and we're comfortable with it, or at least I am. Maybe Representative Nyman's not. So that's it. And I'm not hung up on it at all. That answer good enough? Thank you, Mr. Chairman, Representative Summers. Back on to page 11, we inserted the terms of the charter, and then we struck a whole lot of the language that was really specific to the charter schools that go back into it. That language necessarily needs to be gone to make this type of charter that we're doing. When you go to the bottom of page 11, then we started inserting the language that replaces it. It says, shall be exempt, and this is really a critical part for you. I'm probably gonna get some questions on it. It says, shall be exempt from the statutes applicable to a common school district board, rules of the state board concerning teachers or administrators, local regulations or policies of school board district, unless specifically incorporated into the charter. Nothing in this subsection shall be deemed to exempt the charter school from, and I'll get into that, but you may have questions, because this is the part I was talking about. You may let an English teacher teach math if you think he's able to do it without a certificate. You may do some different things, and this opens up, and I know I'm going to get some grilling. I'm not an education folks, but that's really what it does. And I'll stand for questions. I see my good friend's got a grin on his face, so I'm about to get on the barbecue grill, I think. No questions?
Just Mr. Chairman.
Yes, go ahead.
Mr. Chairman, thank you. And the reason I have no questions is because you and I talked about this, and my amendment didn't touch this, likely on the floor, I would make a run at this section pretty hard.
Chairman Paxton, Representative Summers, I'll do a little bit of explanation on it. On the surface, it leaves it wide open. But in truth, when you really get into it, it says it's wrote into the agreement they make, either with the local district or the authorizer. And I don't think many authorizers are going to let them just go wide open and say, go get a guy out of the hayfield to teach your ag class. I think they're going to put some standards there that say, here's what it takes. but we're going to loosen it a little because if we don't do this in some of the areas where we're at, you may have kids that are 80 miles from town if we end up with it out of school. And this is an attempt to try to figure out how can we hit a happy medium and go back to some little country schools potentially. So
Well, as a former principal of a K-12 school, I know that I struggled with that when you have to have a lot of times a dual purpose or triple purpose teacher in that thing. And fortunately, I think now we have a professional teaching standards board that really kind of gets that. And I think they're a lot more open to giving out conditional licenses so that we can continue with that. Yes, Representative Harshman.
Mr. Chairman, Senator, thank you. But how I read that is you don't have to be a teacher. You don't have to have a degree. You don't have to be a U.S. citizen. To teach in one of those. That's how I read it. It exempts. Chairman Paxton.
Go ahead.
Representative Harshman, thank you. It appears to read that way until you really get into it. And it says that this contract allows whoever does it. I don't see any authorizer, like I said, is going to pull somebody out of the hayfield. What they're going to do, and once again, back to my ignorance in education, I apologize. I'm not sure I'm fine that I have any problem with it going back to professional standards board of the teachers. I'm not an educator, and I didn't realize they were granting the exemptions. They weren't a few years ago. Maybe they're fine. I'm trying to get great education for kids and get some flexibility. The other thing it does in some areas, you may be able to bring some people in and teach some classes that are a little bit different people that are teaching specialized, particularly if you get into some ag classes and some wood shop classes that really don't have to have the exact same qualifications. And if the authorizer thinks it's all right and it's in their plan, I guess I'm probably good with it because I think we're going to have people that care a lot about how we do it and a lot of care not to do it wrong because this is all going to go away. If it's done wrong, it won't last. Believe me, it's got the ability to pull these schools back in, and I believe it'll happen. Thank you. Stand for further questions. So as we go through page 12, this is just your basic boilerplate stuff. Says it's going to follow basically some of the very same standards that we do Public Records Act. Assessment and accountability, we're still going to follow the same assessment, same accountability that we do in K-12 now. Follow all the civil rights type things. Bottom of page 12, they negotiate a contract with the school district governing body, and it had State College or University, and we went to Community College of the University of Wyoming. So if one of these is in a town that's got a college, they may have some commingling with professors teaching some classes. Pretty much existing language on page 13 until we get to line 8 in the middle. Starts talking about the contracted incremental cost for school district capital facilities that are rented at the time of the charter school application, been rented for the median preceding 6 months by a third party. Net loss rental income should be considered an incremental cost. That's trying to cover the local school district, trying to leave them whole. They may have some of them that aren't happy because they can take away a facility under this. That's I'm going to be upfront about it. Is you've got an empty school sitting in your town and it's been sitting empty, but it's on their list. They may petition and come in and rent that facility. Drop down to line 17, and we added in acceptance provided in subsection J of this section. Charter schools does not require pay rent. That's standard language. It's what we do in the ones we have now. Goes down, we add school facilities. Go to page 14, and we added in some more stuff. State Loan Investment Board is the authorizer. The board may instruct any appropriate school district to lease unused or underused school facilities to a charter school under terms consistent with the subsection. That's what I was talking about. You could hit a rub if a district's got a building that they're saving, let's say here in Cheyenne, that they think they're going to use for overflow or whatever, and charter school may come in and be able to get a hold of that from them. That'll be a negotiation. It's one place you could hit a rub if it's an independent board. Drop down to the middle of the page, we're adding some stuff. Then we get in on page 14, middle of the page, charter contract shall. These aren't mays, these are shalls. It's a written contract, separate document from the charter application. So you've got your charter application that does it. Then you've got the contract on how you're going to do it. The contract's the details we've been talking about. Executed by an authorizer in charter school, middle of the page. Line 20, confers certain rights, franchises, privileges, and obligations on the charter school, which those are going to be pretty in-depth because that's how we make sure they do their job right. On to page 15, confirm the status charter school is a public school, and the charter is granted for 5-year terms initially. That's going to be the first term is a 5-year term on line 4. Go to line 6, provides for review by the author, this new language, provide for review of the authorized charter school's performance, including the progress charter school in achieving academic goals set forth in the charter at least one time in each 5-year period charter is in effect. Drops down to line 12, provide for a renewal of the charter if the authorizer and charter school agree to renew the charter pursuant to renewal application. Renewal application shall meet the requirements subsection B of this section. Goes on, specifies the grounds for the authorizer. This is how they revoke the charter. It's terms that they could revoke it if they're not meeting either standards or what's in the deal. And also not only remote, but to not renew it for the next 5-year term. Go to line 16, page 3, new language, set forth the methods by which the charter school will be held accountable for achieving the educational mission and goals of the charter school, including the following. And this, once again, this is shall, they have to do it. They have to provide on line 8, evidence of adequate performance or improvement in the following areas: assessment measures, including the statewide assessment measures, which would be the same as we do K-12. They've got to do attendance rates. Last bill might change that. Graduation rates if applicable, statewide education accountability measures, financial performance and stability. On to page 17, governing board performance and stewardship, including compliance with applicable laws, rules, regulation, charter terms. That goes back to having someone on there if it's not performing correctly. That's going to get pulled out and they'll either get pulled off the board or changed. So if it's not working, it's there. On to line 5, evidence progress towards reaching the educational goals set by charter school. Describe the method to be used to monitor the charter school's compliance to applicable laws, progress in meeting targeted educational performance. On to line 16, specifies that the authorizer and charter school may amend the charter during the term of the charter by mutual consent. Describe the process for amending the charter. Base language that does that. Bottom of page 17, describe specific operating requirements, including all the matters set forth in the application for the charter. These are going to be pretty voluminous documents, folks. They're pretty in-depth and they need to be. On to page 18, specifies the dates for the charter school when they start. And on line 6, have students attending the charter school. Line 9, specify the records of charter school relating to school's operations. School's charter are subject to inspection and copying to the same extent of a public school inspection copy. We're just following the K-12. Line 15, specify the records charter school to the department or authorizer relate compliance charter school terms charter applicable federal laws subject inspection copy. And they can't hide what they're doing. Bottom page 18, require charter schools set annual performance targets in conjunction with the charter school's authorizer. Annual performance should be designed to help each school meet applicable federal, state, and authorizer requirements. I think that's pretty similar to K-12, but I'm not positive. Page 19, line 4, contract, and we struck out some of the existing language to make it so that it accommodates the authorizer, may be renewed pursuant to a renewal application. Then we start going in if they go past the 5-year term. Renewal says going to include any guidance provided by authorizer specifying performance criteria, guide the authorized renewal decisions. At a minimum, provide the opportunity for the charter school to present evidence beyond the data contained in the performance report supporting charter renewal. B, describe improvements undertaken or planned for the charter school. Just lets them go beyond just submitting records. They actually do it. Line 20, detail the charter school's plan for the next charter term so they change and get better or change things aren't working. On to line 4, be submitted by the governing board of a charter school seeking renewal not later than December 31 of the year preceding the start of the school year that the charter expires under normal renewal application guidance issued by the authorizer. Line 10, middle of the page, authorized to make a final ruling on the renewal application no later than April 1. So that gives them 3 solid months to review the application, work on it, following file a renewal. Under the subsection April 1 deadline does not apply to any review or appeal of a final ruling. School district denies approval of a charter. Charter school board may appeal to the State Loan and Investment Board for a de novo consideration of the renewal. State Loan Investment Board shall consider the renewal, and if the renewal is approved, shall be the authorizer of the charter school. Bottom of page 20, after the charter school, a charter school authorized by the state loan, been in operation for years, been renewed by State Loan Investment Board. State Loan Investment Board may delegate to the school district where the charter school operates any of the function authorized under the article. That allows them to hand it back to them if they've had this split one and they can get it back. Line 6, page 21, charter school and school district approved delegation functions. Charter school shall retain the right to seek renewal of the charter from the State Loan Investment Board. Drop down middle of page 21, line 16, we struck yield back to authorizer language. And then at the bottom of 21, we added language that gives the applicant right to determine authorizer to apply and may apply for a different authorizer for renewal of the charter. State Loan Investment Board may reject a renewal application for existing charter school if the renewal is to avoid necessary corrective measures, including closure of the charter school identified by the authorizer. So it stops them forming a new board and doing it. It also allows them to go back and merge with local school board if they choose and the authorizer allows it. Page 22, new language. School district denies an application to convert a school to a charter school. Under subsection B, applicant may appeal to SLIB board. State Loan Investment Board approves application shall be the authorizer of the charter school. This is where if they vary from the district, gives them the ability to form the new board. And that's where we get into bottom page 22. We had language providing the enrollment should be open, and this is the language that goes to the extent seats are available within the applicable grade level, subject to Wyoming statute 21-3-304C. Number of applicants for enrollment exceeds available seats. Charter schools shall, subject to the statutes, hold a blind lottery to determine enrollment. Students enrolled the previous year should be guaranteed a seat. The applicants with a sibling enrolled in the charter school should receive a preference. That's the only preference there is. If you've got a brother or sister in it, you're going to get a difference in the ranking on the draw on it. Other than that, it's just a blind draw. If you've been there, you get to stay there. Go back to authorizer language on the middle of 23. On line 12, evidence of adequate community support. And excuse me, line 16, evidence plan for the charter school is economically sound. That's all going to be reviewed before they get their charter. Bottom of line 23, we've got existing language. Move on to page 24, and on line 6, we start into the new language again. And in case of a proposed charter school, the plans to establish full-time virtual charter school. The application shall additionally require the applicant to provide a description regarding the methods by which the charter school will, we go through it, how they ensure sports are available for the students in their homes and regions, including parent-teacher conference interactions, monitor student outcomes, establish, implement legally permissible criteria and process for enrollment based on existing support needed. On to page 25, provide the desired enrollment level of school for each year, charter contract not to exceed 250 students in any given years with increases in enrollment from one year to the next based on whether school meets its performance requirements. Chairman Paxton.
Representative Summers.
Mr. Chairman, thank you. And so Senator Driscoll, there, on this page, you have really two qualifiers. One is the 250 students and the other is the 20% of enrollment. And so I'm wondering where you got those numbers.
Chairman Paxton, Representative Summers, and I'm not sure this is exactly proper, so if I'm out of line. The bulk where I looked at was I attended the Barney Charter School deal, which is Hillsdale College. They educate about 25,000 students a year. This is based off their model for optimal size on the bigger schools is the way they do it is they generally will start it and then they start adding classes as they go up. And that would be if they were going to do one in one of our larger cities, which I think we only have 3 towns in Wyoming that probably fit on those bigger school models. But that language came directly from them, and it's, I call it a success curriculum. This big part of this bill was by borrowing from what they've done that's been very successful. They've got very high achieving students that take everybody, and they've got great results. So, middle of page 25, provide detailed budget for the school and provide a funding level per student for the school that's based on that budget. That's going to have to fit in. If they can't do it within the money they got, they can't do it. Line 12, provide data for oversight, funding, renewal, closure decisions, full-time virtual charter school specific goals regarding student enrollment, attendance, engagement, truancy. Same thing we do in K-12 now. They're going to have to follow. Provide more than 20% enrollment be outside the school district where charter school is located without prior improvement of the state loan board. So we're not going to be dragging a big bunch of students from across the line unless it's approved. On to page 26. This is the entire page is new language. Proposed charter school intends to contract education service provider for an educational program implementation or comprehensive management. Applications shall additionally require. So if they're going to bring in a firm that helps them do part of the stuff, these are additional requirements. They're going to have to provide evidence the education service provider's success in serving student population similar target population, including demonstrated academic achievement as well as successful management and non-academic functions, if applicable. That means whoever's going to come in is going to at least have some basic experience or bring people in with basic experience. We're not trying to create a brand new thing. Middle of the page, provide a term sheet setting forth the proposed duration of the education service contract, roles and responsibilities, governing board, school staff. This just back to the whole 9 yards, makes it where it's a transparency section that makes it where the authorizer or the school board can see what's happening, going on. Go to page 27, shows the handout. Go to line 4, disclose and explain any existing or potential conflicts of interest between the school governing board, schools leadership, the management team, proposed education service provider, any affiliated business entities. That ties back. It's transparency. They're not hiding what's there. They're going to have to say what's there as far as conflicts. Line 10, case proposed charter school from applicant currently operates one or more additional schools inside or outside of Wyoming. The application will additionally require the applicant provide evidence of past performance capacity for operation of additional school. So if you're coming in with one of any size, you're going to have to show you've got the capability. We're not interested in starting one that somebody gets bunched, we get in a mess that we didn't properly do kids. Line 17 strikes out superintendent of the school district, moves to authorizer, same way through the bottom of the page. Back to authorize. Line 28 is existing language, basically, other than the bit at the top. The authorizer. On to page 29, State Loan Investment Board shall submit all applications received under this section to the Department of Education for review of compliance with accreditation requirements. Department of Education submit a report of this review, State Loan Investment Board. I make sure the application is complete. We got education people looking at it and making sure that it's a correct application and that they agree with what they've laid out. Rest of page 29, we move from on line 13 from 30 to 60 days after receiving the application. Gives them a little more, and that's when we start getting the slip board. They probably need some more time. Line 16, we go back to the authorizer, and then at the bottom of the page, application review process shall also include an in-person interview of the applicant or applicant group. So they're going to have to come in front and do it. They can't just send one in and wait and see if they get it. We're back to language on the authorizer and changing it through the middle of page 30. And then at the bottom of page 30, we're into the district board, and that's all struck out because of the way we're working with the authorizers.
Hold on, just go ahead.
Mr. Chairman, thank you. On the bottom of page 30 and you'll see in my amendment, I reinsert some of this. One thing that I don't think, that's not covered somewhere else, and I'm wondering why you left it out, is if you're going to do one of these, we need to understand what the potential effects of that could be to that district. And I don't think, unless I missed it, I don't think you have it anywhere else in there. Because you strike that language. In other places, you kind of reinsert similar language, but I missed that if you did. So if you do reinsert that, let me know where that is.
Chairman Paxton, Representative Summers, I think that's a good catch. And I didn't intend to do it, but I think what you just said, and I'm, without sitting down and doing a bunch of research, but I think you made a catch here. I think it's an oversight. So page 31, we're back to all the authorizers. Top half of 32 is existing language. And then we drop down to the bottom part and we do the existing language of charter. We go back to the contract language, and we've handled this renewal stuff up above prior to the deal. So it strikes that out. And then at the bottom of page 32, charter may be renewed for successive 5-year terms, providing the authorizer may vary the duration of the term based on performance demonstrated capacities, particular circumstance, charter school. Authorizer may grant renewal of charter contract, specific conditions for necessary improvements to charter school. That kind of speaks for itself. Back into authorizer language, middle of page 33. And then we line it up with another piece of statutes on the charter school. We've added some language in. Bottom page 33, it's back to authorizer language. On to page 34, kind of conforming on the top, starting line 6, says any charter school may offer a private pension retirement program for participation employees of the charter schools designated in the charter. Their money's coming in block grants, so it's going to be different. Their pay scales are different than the state is. Allows them to go ahead and do a retirement program. Line 10, amount provided for retirement of a charter school under this section, its employees should be equivalent to the amount authorized for retirement within the school foundation funding provided to the charter school. So it says it lines up with the school districts we've got. Bottom of 34, back to the authorizer language again, and then we strike, do the charter and assure the state board students attending charter school receiving the education consistent with educational opportunities available to all students. We covered that earlier in the contract and the charter both, that they've got to do that. Added some school district language, middle of page 35. We dropped to the bottom of page 35. We've got all new language here. And this goes into the ADM funding. If a charter school authorized state loan investment board and the school district where the charter school is located do not agree on funding pursuant to sections A3 of this section and notwithstanding 3 of this section or any other provisional law, funding the charter school should be calculated as provided in this subsection. Nothing in subsection should be deemed to prohibit a charter school and school district negotiating an agreement. For last page, charter school students receive services from the district. So funding for the charter school should be calculated as follows. That section is somewhat important because it allows the district to charge money if we're bringing kids in to do either sporting events or certain programs, which we do have happening right now. The districts are just forced to take them. This says that the districts are going to get some compensation back. Line 5, all funding for school district under the statutes is attributable to charter school shall be reduced to 85% of the amount that would otherwise been calculated. So if they're not getting along, gets formed, they only get 85%. That's the carrot and the stick. Line 10, charter schools should be entitled to funding as provided in subsection C of this section from the reduced amount calculated under paragraph I of this section right above. And then we cite the statutes. Effective date of July 2021. Closing.
Okay, go ahead.
Mr. Chairman, thank you. And just due to time, I didn't have time to track out every repealer. So if this bill moves forward, will you get us a one-pager on what these repealers are so I don't have to track it out?
I'll get staff on it because I'm going to be honest with you. I didn't do them. Our drafting staff did it. So I'll try to get you a rundown on that. We'll get a hold of Matt and see what we can get done.
Important to have
My
that.
apology that I didn't have it done. I usually pack statute books and I didn't do it. In closing, I think this is really an important tool going forward. Now's the time for it. When we look at where we're at, I don't think it's going to have a major effect on existing schools. We've had the charters there. They haven't made big runs at our big schools, but I think they've got an absolute role in these rural areas for us to be able to deal with flexibility rather than closing schools. You know, I really don't want to drive down Main Street where I live at and have another community center attached to it. That was our old school because our kids are going 60, 80 miles away to go to school. We're 30 miles from the base town, and then we got students come 30 miles north on gravel. This is a lifesaver line for some of these rural, and you know, we can name them. I happen to know Harshman, Representative Harshman could name a pile of them: Clearmonts, the Casey's, the Hewletts. And folks, as we get into this funding problem, you can sit and about cry because it's the end of your town. You close the school and you don't have a town. That's why I'm here in front of you. So with that, I'd stand for questions, and I thank you for your time.
Okay, we'll start with Representative Summers and then go to Representative Newsom.
So Mr. Chairman, and to the good bringer, I mean, because I respect you so much, you know, I'm going to work on this and I'll vote to get this out of committee. But I frankly think charter schools have been the demise of public education across this nation. And I think it's taken kids out. It's left the worst of the worst in public schools across the country. And in some places, charter schools have been in the worst and helped those places. I think there is opportunities. The question is how you do it, and is this the right vehicle? And it's a lot of bill to digest in the amount of time that I've had to digest it. And so I'm going to try to pull in some things that I think are important, and then we'll just see where it goes. But just in general, I have a real problem with charter schools.
Representative Newsom, I believe you were next.
No, it's not a question.
Thank you,
Chairman,
Mr. Chairman.
Ironically, I do agree to some. I differ a tiny bit if I can kick back. As I did the research on where charter schools are at, there's a couple states that they approach 30–40%, and they have been a problem. But a vast majority of the states that have charter schools, they haven't had huge impacts on their system, and they have specialized in getting kids alternative education methods that might not perform well in the standard schools.
I would think there'd be a lot of difference in the size of the community. On these smaller communities, you're gonna take every kid that walks in the door. On a bigger community, I think you'd be, you know, a little more selective on how that happens. So it probably work a little bit better in the real small community than it would in the larger community. Representative Newsom.
I had a question early on in your presentation. And even now you mentioned the demise of small schools and that your school has gotten smaller and smaller. Has the enrollment decreased because students are finding alternative education opportunities, or has the enrollment decreased because of a population decrease of students in your district?
Go ahead, Senator.
Chairman Paxton, Representative Newsom, combination of both. I think we see more homeschoolers than I ever saw growing up. When I was there, every kid went to school. We do have a number of homeschoolers, but in addition to that, we've lost population. I keep using personal examples. Between my ranch and Representative Nyman's ranch, they used to run a 40-person school bus. To the best of my knowledge, there's 2 students on that route left, or 3. That's how consolidated part of our rural areas got. And that's just tragic, but it's fact of life. Our urban areas are growing, our rural areas are shrinking, and we're trying to deal with it. Thank you.
Yes, Representative Harshman.
Thank you, Mr. Chairman. And I agree, you know, the old Tri-Cities, you know, Midwest Edgerton and Lynch used to have a couple thousand people. Now we're under 500 easily, all those. And older brother had 40 and his graduating class had 17, you know. And so it's just all over America, rural America. But I think the thing about this bill though, I mean, you touted it as kind of a savior for small schools. I just don't. I mean, I think of these companies that we're asking to come in here. I mean, because we already have a charter school law. I mean, it's worked very collaborative. I don't think anybody's going to work as hard for the charter school in Albany County as the Albany County School Board has, or even in this county. I mean, this county, what they've done for this local charter school, it's amazing. I just don't think. Anyway, but I guess I don't see this in a small school thing. It's going to be in a bigger town. It has to be where there's more customers and you can have that customer choice thing, don't you? I mean, I just don't see this saving Hewlett High School. I think the state keeping Hewlett High School open, you know, with small school adjustments is, and hopefully this whole thing turns around and we get more people back someday. I mean, that, I guess, don't you agree, Mr. Chair? Mr. Majority Floor Leader?
Mr. Chairman, Representative Horstman, I partially agree. Part of this bill is geared so you can have the firms you're talking about potentially come in. But the other part of it's this, some of these districts are just closed to charter schools and a lot of them are rural districts. I hate to speak and I hope I don't get a buzz on my phone as I'm talking here, but I get a feeling my local school board's probably not very keen on a charter school. But I can certainly see a group of our teachers getting together and using the school that got abandoned when we ran out of money to teach. My daughter's a teacher, and I can see a group of them coming in and actually running a charter school on a small basis. And I do think they work. And I think it's potentially a money saver and a savior in general for that end. So it's both ends of it. One of it is, you're right, the economic model for a Barney charter school or someone else is in a bigger town. Absolutely. I'm not gonna dispute it a bit. But the smaller ones I think are there as well. And I think in the bigger town, because of the way this bill's structured, they're not stealing students out of your school. They're providing an opportunity to students that want to have an alternative to what's there. And because of the way it's done, you can't cherry pick kids out of NC High School or Kelly Walsh. It's a random pick. So it's kids that may be going to one that either they or their parents want a different type of education or a different type outcome after the education. And I think there's a role for them in that. Thank you.
Representative Obermuller, I believe, was next.
Thank you, Mr. Chairman. Senator, on page 6, you have at the bottom is the definition of authorizer, which is an important word throughout the document. My question for you is, does this bill hinge on this definition to include the State Loan and Investment Board?
Chairman Paxton, Representative Obermuller, it did as written, but I will tell you, you're going to see Representative Summers bring an amendment. I'm very aware of the amendment. I'm not opposed to it, and it will change it to a different authorizer. And the whole point of the bill was, if a local school district wasn't going to do it, who is going to be the authorizer that does it? That's a policy decision we make. And I think we're going to see that Representative Summers disagrees with it being the SLIB board and would rather it be someone else. And I'm amicable to what it takes. I do think you need something there. There's a local school board just says, look, we hate charter schools. We just heard someone say it over your group, that there's an alternative. They say, look, even though you hate them, the parents in the community want it to be there. They think it's an option. And that's really what this does with the authorizer, Representative Obermuller.
I think Rip, okay, follow up.
So Senator, how does it save a small rural school? If a school district has decided to close it down, how does this bill save a small rural school? Thank you.
Chairman Paxton, Representative Obermuller, and I'm hoping I'm not wandering in. Like I said, I'm not an educator, but our existing K-12 laws are really strictly defined on class sizes, a whole series of the way you go about it. Charter schools are exempt from a big part of that. So you're teaching more in the old country school fashion. It's really hard, Hewlett, I can put it that way. I go back to, we have too many teachers in our school for the number of kids we got just because of the logistics, putting the classes together. And this is going to allow some alternative ways to maybe be able to do it using the same money, but a different way, because the charter does let you get outside of some of that. That's the cheat they get. And I'm honest about it. It lets them do some things that I feel sorry for our local districts that they can't do now. And this gives them some options, and maybe if it doesn't work economically, I can tell you, it just won't happen. There won't be any of them, but I kind of think you might see some try it, assuming our school funding gets worse, which we all pray for another oil boom. I hope we can keep paying for our little schools.
Representative Nyman, I believe you were next.
Thank you, Mr. Chairman. Thank you, Senator Driscoll, for bringing this. I guess I'm trying to kind of understand a little bit about what is going on with the charter schools. I mean, obviously, there's charter schools that are operating right now in the state of Wyoming, and some of the background on their successes or failures, and kind of understand a little bit of the dynamic, I guess, of what's going on even in Laramie here or Albany County, or give me some background on how and what's going on or going wrong with them. And so I can kind of have a little bit better grip on the pros and cons of this.
Go ahead, Senator.
Chairman Paxton, Representative Nyman, I'm not sure I'm the most qualified. I'm not sure maybe Representative Harshman or even Chairman Paxton may be better than me. I will tell you, I've visited with Snowy Range Academy's people. What I saw there was happy teachers and happy kids. That's important to me. My daughter's a teacher. It's hard. And that's part of what I see is they teach a different style than we do. And I think we've boxed our education system into where it's not fun to teach anymore. And that's part of what this is reach out to do it. Now I hear that the school here is not quite the same in Cheyenne. But as a whole, the charter schools I've talked to, and there's been quite a few, they're happy. The teachers are happy and the kids are happy. They got good grades. That's why I'm here.
Just a comment to the committee. We're plowing an awful lot of new ground here. There's no doubt about it. And I don't think we're going to find the perfect number, the Cinderella side of this thing in the short period of time that we have available. I think the main question to us is, are we willing to take a chance to try something new to see if we can make it work? And, I can see this thing maybe evolving over a period of time. And if we open the door for this, it seems to me that we'll probably find some unintended consequences or some unintended things as we move forward with it that we can fix as we go. But if we close the door to it, we never have the opportunity to know. So just a comment from me to the group. We're only about 20 minutes out of running out of time here, folks. And we haven't taken any public comment yet. What's your pleasure? You want to continue to grill the good senator and yes, Representative Harshman.
Mr. Chairman, and perhaps the majority floor leader, just thinking of our schedule. So we've got Monday and Wednesday in this committee. Because Friday's the last day as crossover. So you could do advance one day. I think we're going to plan on doing some. I mean, I'm just thinking worst case. I'm just trying to get our drop dead date. Monday's got to really probably be the day. And if you had to come back Monday night or something, to keep working a little bit. But I guess, so I think we got time to keep working this is what I'm saying. I think.
Mr. Chairman.
Go ahead, Senator.
I'm going to leave myself at your mercy. I will not be here Monday. I have faith that you guys will make the right decision, but I have to be back at home Monday and I will not be in the legislature Monday. So I'm very comfortable with you folks going ahead. Obviously, it's the way the process works. So if I'm not here, it's not because I abandoned my bill or I'm mad. I've got a prior commitment.
So
go ahead.
So we better work you over now. We get our questions a good majority floor there now.
Yeah, and maybe we should do that. I was hoping that we could take some public testimony, but maybe since we have the good senator here, that if there's more questions that you have about him, we'll go ahead and continue with this line then, if that's okay with you, Senator. Representative Summers.
Mr. Chairman, my apologies. I've sent my amendment out, obviously to the committee and to you. And, but the public has no idea probably what I'm bringing. And so I just want to ask, just mostly so the public understands what I'm bringing, and then you can answer some questions. So the concern that I had in your bill was who is the authorizer and who is currently the authorizer. And so currently the authorizer is a school board. So that to me is an elected body of local people. What I didn't like about yours, I like the fact that you kind of went out and got an elected group, right? But not really anybody locally. And so what my amendment will do is it makes the superintendent the authorizer, but subject to a vote of the people. And it can be as small as a voting district or as large as a school district. And there's two ways that can happen. The superintendent can, the applicant can bring an application, and the superintendent can then say, we'll go out to a vote of the people in this area that you have defined. And/or the people themselves can come with a 10% of the pop, just a referendum, and they can bring it on themselves and put it on the ballot. And that way you have the entire, we've often heard that, well, if it were school board members, they're biased towards the district. They're not paying attention to the people. So, but this way we bring it back to a vote of the people. And so I want to get your feedback on that concept. Most of the rest is just conforming language, but I want to hear your thoughts on that idea. Thank you.
Go ahead,
Chairman
sir.
Paxton, Representative Summers. On first blush, and by the way, I'm not being ambushed here for people listening. Representative Summers worked closely with me and told me what he's up to. Like about everything I do, I like my idea better, but I'm not necessarily, if it's a killer on the deal, my goal is the same as is with all my bills, is let the expertise of this body as a group decide what they think's the best, and we'll go forward with it. Because I've found in the past things I thought were really good that people changed. I found out they had pretty good wisdom. And that being said, you're not going to see me stand up and rip the bill into shreds or be angry about what goes. I'll accept what comes, and we'll set a conference, and I'll do it a lot more, because it will end up in a conference, and I'll spend a lot more time doing deep thought.
I believe we have Representative Conley over here virtually that would like to ask a question. Go
Hey,
ahead.
Chairman, can you hear me okay? Yep, okay. Thank you. And I just wanted to respond a little bit to the good Senate Majority Floor Leader about what's going on in Laramie, and then honestly follow up on questions about the authorizer. So we have 2 brick and mortar charter schools. They've been around for a long time. And on honestly opposite ends almost, if you will, of the educational spectrum. Snowy Range Academy is what was considered a very traditional school. Uniform is a strict curriculum, strict behavior, expectations, and then the Montessori school. And just as a little history, not that I was thoroughly involved with either of them, but I did have conversations with both of them. And both of them meaning the parents that were involved, as well as the school district, especially with the Montessori school. In both cases, the parent group did not fully understand what it meant to be a charter school, and that it meant that you needed to follow kind of the rules and regs of any public school. The Snowy Range Academy group of parents I spoke with early on really didn't want to take any special needs kids. because of their kind of behavior. They give little chits if you misbehave. They didn't want kids that were ADD or have to deal with them. The Montessori school, on the other end, did not want testing. They did not want their kids to participate in testing because that's not the Montessori way. But as public schools, they needed to do that. And certainly they came to that understanding, but the parent groups didn't thoroughly understand to start with what it meant to be a public school. It's not simply a group of parents getting together and deciding that honestly, they want a private school that the state pays for. That being said, I had more conversations with the school district, with the Montessori school getting started. That's the more recent one. And again, my school district will probably not like this, but my perspective of it was that the school district just didn't want to listen about establishing an additional choice for students in a medium-sized district. I'm all in favor of school choice. I don't believe that all kids learn in the same way. I think the models that exist in both Snowy Range and Montessori are better for some kids. That being said, our district did everything it could to basically just say no. That being said, our statutes are good enough the way they are right now that those parents prevailed. They simply prevailed. There was no need for a second authorizer. And that then gets to what I think is the major element, Mr. Majority Floor Leader, of your bill is about that second authorizer. Basically, what it says to a district or to that negotiation is as soon as the district says no, then the parent group can step outside and go to someplace else. And this isn't the first time that we've looked at a bill like this. It was probably 10 years ago, we had one where the Community College Commission was being put in as the second authorizer. Without any honest discussion with the Community College Commission, they would have done it if obligated to by statute, but they felt like they didn't understand all of the issues. I'm curious if you've had in-depth conversations with the SLIB board about that, because it is really outside of the purview of what they do. And I'm asking that in part because ultimately, even against the wishes of the Albany County School Board at the time, that Montessori parent group prevailed. And now they have a very good relationship. But that's my perspective on what happened there. So I want to go back to the meat of your bill, which is about that authorizer. And why put in an entity that knows so little about first education in general, and second about the specifics of a particular community like the local school board does when we have an example where our statutes right now work. Thank you, Mr. Chairman.
Senator Driscoll, would you like to take that on?
Chairman Paxton, Representative Conley, I very much appreciate your comments and I understand them. And you're absolutely correct in a district that you've got enough people to go work with a school board to go do it. But my belief is you do need the outside authorizer in the cases that they just flat won't. And you do see that in Wyoming. As far as dealing with SLIB board, I talked to multiple members of them. Some other people that helped me with the bill visited with some of them. And we had reasonably good conversations with Superintendent of Public Instruction, whether it should be the State Board of Education or not. And ironically, she's on the SLIB board. And I think, I hate to speak for her, but if she comes and testifies in front of you, I think she thought they were good because they don't have to know about education. They do what the SLIB board does. The application and the contract is all done and gone through by the Department of Education. That's who does the application. What the SLIB board is actually the arbiter that decides whether it's been done correctly, if it was unfairly denied by a local school board. And they merely say, we think you've unfairly restricted it and we're going to allow it to happen because of that, albeit at a lower level. We put in a a whole lot of sweeteners, both sides, to make this where they get along. I'm not doing this to fight with local school boards. I'm doing it to give them utmost encouragement to do the right thing to provide choice to their students. Thank you.
Representative Harshman.
And maybe we can, thank you, Mr. Chairman and Mr. Majority Floor Leader. I appreciate you. Great job on the presentation of the bill too, since I won't see you on Monday. Really nice job. And maybe I'm gonna just start giving you all my bills. You can run them all. And, but yeah. No, I know. I see how this deal's going down. That's not my first rodeo, but anyway. I guess and maybe somebody, and maybe we can get the answer over the weekend, and I'm thinking in Natrona County when we had a charter school and it just kind of ran out of steam, and we've got schools of choice where we've got differing, but I wonder what I guess it's been a pretty collaborative deal, I think. I just don't know the experiences in all the school districts. So if they've been just this heck no attitude, and maybe somebody's got that info. How many applications have actually been out there and how many have been denied? How many approved? It's not that many. I mean, it's probably a dozen or less over all these years would be my guess. And maybe 6 and maybe 5 have been approved or something is what I'd think. I think we'd be surprised how collaborative, but I don't know. And maybe somebody out there, I'm looking for checking for understanding. I don't see anybody doing this. I see one head nod maybe. So maybe we can get that. Thank you, Mr.
Go ahead, Senator.
Mr. Chairman, Representative Harshman, I have looked closely at your district, and your district has done handsprings to try to do alternative schools. I get it. You've built brand new facilities to try to do it, not just moving into a shopping center. You've built schools, and I think the recognition is there, particularly by me. This is a bumpy road, even if you approve it. It's not, education is not for the weak of heart. I don't take it for granted, and I'm not an educator. But I really strongly believe that if we're going to do this and do it right for our kids, we need to think outside of the box. And this is a tool that may never get used. It may get very lightly used, but it's still a tool there. And I just hate not to put every tool we can in the box to get our kids educated and have them educated in a way that their parents feel like it's meaningful and it's meaningful to the kids. And I can tell you personally with my kids, our existing school system didn't work very well for my son. Wanted to be a rancher. And I want a different choice for some of those kids.
Right, Mr. Chairman.
Yes, go ahead.
And Mr. Chairman too, and going back to what, and I wrote that down, what you said, your daughter, a lot of the fun's been taken out. It's been a heck of a tough year. I hear you. I've been married to a 35-year first grade teacher. I will say this to all of us though. We got to make sure we're not part of that problem. And I mean, what we say as leaders matters. There are people watching this all the time and say, geez, why am I busting my rear end and staying here late on Friday, coming out Saturday and Sunday and doing, hell, they're going to cut my job anyway. That's kind of the thing out there. And I think we got to, we don't say that about our firefighters or our state employees, or we just got to be really careful because this is a cornerstone of our state, our education, and our constitution. And we are constitutionally required to be the ones to oversee it. Right? I just think, and so I'm not saying that you have, I'm just saying all of us, I'm giving us all a friendly reminder because we can get in a bunker sometimes and instead of solve problems, kind of use problems to leverage them for another deal. So, but anyway, I appreciate your work on this. So thank you.
Go ahead, Senator.
I do. Thank you. You woke something up in me, and I really do. I think we have a wonderful school system. And for anybody out there listening thinks I'm doing it because I think they're not doing a good job and they're not dedicated, they're wrong. It's merely to provide a choice that's different for the students. I've been a big supporter, and I know Representative Harshman, you know that. I think our system does an absolute wonderful job and our staff that run these schools are the most dedicated people working under some of the hardest circumstances I've ever seen.
Well, I have Representative Nyman down there that's been waiting in line here, so.
Well, that's all right, Mr. Chairman. I appreciate the opportunity. On that, and I think the representative from the center of the state, can we use names here? Representative Harshman. He made a statement there that I think is very true. And that's the major part of what intrigues me about what you're wanting to do, Senator, is that education is the foundation of our state and our nation. And the ability to educate our young people and to diversify how we do that, to look at all options, don't live inside the box, look for different opportunities to be able to provide education so that we have a strong, nation building, growing. And I think we see it a lot more, and I've seen it, and I've had a lot of visits with people that want to have options. They want to have the opportunity to maybe not do it exactly the way it's been done. And I think the parents in this equation, along with the deep respect for educators and what they do and the sacrifice they make, another thing is that we have to recognize that we have parents and that are out there that have a responsibility, in my mind, to see to it that their kids have those, are pushed and driven to provide those opportunities by us to allow them to make those choices so they're more interested in it. Because, let's just be honest, there's folks out there that are kind of disenchanted with some of the options, and they're wanting to figure out ways to get their kids educated and do it well. And I appreciate you bringing this. I do. I think this is a conversation that has to happen. I think we need to look at diversifying and thinking outside of the box and looking for new ways to educate our kids, and so that we keep education in the forefront of what our state needs. And I think a lot of that has to be done through diversifying those opportunities. So I appreciate your bill, Mr. Senator.
One last question, and we better go upstairs and go to work. Yeah. Go ahead.
Mr. Chairman, thank you. And, so then this I actually just thought of, and so I'll just throw it out at you. What if you made the effective date of this in 2022, 1 year out, and then we actually have it as an interim topic. And if we think there needs to be some refinement in the statutes, by the time it goes into effect, it will have another legislative session to kind of make sure. I mean, this is a big bill, majority floor, they brought really late, and it's really hard to digest it this quickly, just to be flat honest. So your thoughts on that idea?
Go ahead, Senator.
Chairman Paxton, Representative Summers, I'm totally open to moving it. There's nothing in the works of anything happening I know about to move it a year or there. I would like to see the bill passed, and then the interim could work on refining it down and bring people in. And I think you'll find a better product doing that. You have zero kickback from me on that, because like I said, there isn't anything that's got to happen tomorrow. It's how do we provide this opportunity? And that's a very good option in my belief.
And the other thing that I thought about too is that maybe we need a pilot program. There's a lot of new stuff in this thing, and maybe we need to approach it with a little caution and see how that works out. Maybe start off with no more than 3 schools or something like that to see. But we've got a long ways to go here on this yet, and so a lot of dialogue left to take place. But great idea, and thank you for bringing it forward. I happen to come from a school that really could have benefited from that, and I've told people before, drive through Manderson and see what's left of it, and look at that beautiful Manderson-Hyattville High School that's to be torn down here very soon. It's a sad
Chairman
thing.
Paxton, the playground equipment from it sits on my campground right now.
Does it?
Really nice stuff. And I really thank the committee for giving me what I feel is very fair hearing. The initial drafts of the bill, back to your pilot, was my initial runs was to put in 3 schools as a pilot. So it's been thought about. Thank you.
Thank you for your testimony. Couple of quick things. Today is the deadline for us to turn in our interim topics, and we need to talk about, or think about anyway, some dates for our summer meeting. And I'm assuming maybe we want to meet twice. Would that be acceptable to you guys? And maybe, do you want 2 days at a time, or do you think we can do it in one? Depending on how much stuff I guess they give us from management council, huh? Okay, we can probably make that decision later, but if there are any dates that you absolutely can't make it, that would be the best for me to know those dates. So if you have them, email them to me and before 5 o'clock tonight, and any other ideas that you have on interim topics, please let me know. Okay, meeting is adjourned.